So, today the topic of discussion is Indian Registration Act. This act is very small but very significant from examination point of view, as well as anybody who is in practice, he or she must know the importance of this act. Fine. So, should we wait for some more student to come, or say yes, if you are there, you are, if I am audible and visible to you, if everything is fine, then we can proceed with the lecture. See, initial 5-10 minutes of my lectures are very important, which are not required to be missed, because once you understand the definition part, the conceptual clarity about the object and purpose of the act, then things become very easy for you to understand it. That also create a sort of interest, and you start liking, loving the act, and once you understand the theory, or you can say the gist of the act. See, Indian Registration Act 1908 deals with the registration of documents. Now, why do we require to register a document? First, you need to understand it. Fine. Now, through any document, if some interest title is either declared, created, assigned, or exchanged in somebody's favor, that requires our registration. Now, for registration, some books and registers are kept at the office of the registrar, which we will read in the act. Fine. Therein the endorsement or the entry pertaining to that particular document which has been executed by the party is registered. Now, the purpose of registration is one, that you can have an authentic proof of the document which has been executed. One, so document become the authentic one and it got the legal sanction. Two, that parties to the transactions becomes absolutely free from any kind of fear or threat to their right or the title which has been created through that document. Fine. Third, anybody whosoever is going to enter into a transaction with regard to the property which has been endorsed in the document, he or she may know the status of the property quickly. Fine. So, with the help of it, you can say that you can prevent the fraud also. Fine. If say A and B, there are two parties, they enter into an agreement, although they enter into an agreement privately, but once they registered it with the office of registrar who has been designated and appointed by the state government, fine, whose work is to upkeep and maintain the record and give an authentic proof of the transactions of the document, fine, not transaction of the document, fine, then you are secure, and the persons whosoever is coming in future, like to deal with that property which has been inscribed in the document, he can know the status and he would be free. And this document is a public document, one can obtain the certified copy of it after paying the requisite fee also. Fine. So, the job of the department is to preserve the document so that preserve the document so that the fraud could be prevented. 1. 2. Authentic proof could be maintained. Fine. And 3. The sanctity to the transaction or the title. Otherwise, how would I come to know that this property belongs to me unless or until it is registered, or how could the world at large would come to know unless or until it is registered. So, registration has been meant for this purpose only. Fine. So, in section 17, certain documents have been provided which are compulsory registrable, and in section 18 some documents have been there which are optionally registered. So, we will read these two sections are very important from registration point of view, section 17 and 18. Fine. So, section 1 talks about the extent and application, J&K is now part of it. So, it applies to the J&K as well. Section 2, as usual, as per the other act, defines certain definitions. For example, here in the definition of lease, definition of immovable property, fine, and definition of addition, and the court, India, etc. These have been provided. So, lease, immovable property, movable property, and addition, these are very important definitions. Fine. Section 3, that talks about the appointment of the Inspector General of registration, the person who is heading, I mean the entire department is called the Inspector General, but these powers are further designated and delegated by the state government to the registrar concerned, who act as a registrar once they deals with the registration of document, or who act with the who act as a collector when they perform the revenue job, I mean revenue collection, I mean so then they call the collectors, fine. So they are delegated the powers of the Inspector General of Registrar. So again there are, I mean state, district, sub districts, I mean sub registrar, registrar, I mean they are the designated authority under the acts. So 4 is repealed. Section 5 deals with the district and sub districts, and section 6 deals with the registrar and sub registrar, as I said, fine. So, and the section 8 deals with the inspector of registration offices, and section 9 has also been repealed. Section 10 talks about the absence of registrar if the vacancy is created, absence of registrar in a particular district, fine. 11 absence, and the most important, actually the act starts from section 17, which talks about the compulsory registrable documents, fine. Section 18 optional, then important section you can write down. 19 is important in this act, which says that when can a document be refused to be registered by the registrar. So if section 19 say, if I mean the language is not understood in which the documents have been, I mean this has been drafted, that language is not understood, because that language is not the language of that particular state where the document is to be executed, unless or until it is supported with the translation, fine, then it cannot be registered. So the registrar concerned could say, could refuse to register the document, fine. Similarly, section 20 say, if in the document there are interlineation, blanks, fine, or alterations, fine. So I mean then it could be refused unless it is signed by the attester, means the persons who are executing the document, they sign if some mistakes has occurred, like some error has occurred, and I mean some interlineation has been made, unless or until that is removed, then the document could not be registered, fine. So section 22 says that if document is pertaining to immovable property, wherein the maps, boundaries, directions are required to be mentioned, if the description of the property is not there, then also it could be refused to be registered. Now section 23 to 26 deal with the time and time of the registration. So time for presenting the document is, say today we have executed the document, within 4 months from today it has to be, I mean referred to the sub registrar for the registration. So 4 months have been provided under the act, I mean section 23, fine. Section 23A, I mean this was incorporated later, A, it talks about the re-registration of documents. Suppose I mean I am a sub registrar, the document was produced before me for the registration, and I got it registered, but later on I came to know that the persons who have actually produced the document was not authorized to do so, fine. So he was not, I mean supported with the kind of right power of attorney. Then if some complaint or objection with regard to the document is made, then I could get it re-registered also if it is produced by the appropriate person, I mean the person who was actually authorized, if is produced by him, then it could be registered, fine. So re-registration जो है वो बाद में incorporate हुआ सही से. Then if several persons are, I mean executing the document, 24 deals with that. Say first A signs, then B signs, then C signs, and D signs. The D suppose is the last person who signed the agreement, I mean who executed the document. Now the period is to be reckoned from the last person's executions, fine. So section 25 24 say so only, okay. And 25 says if the delay on the part of the parties concerned who were supposed to, I mean produce the document for the registration, they could not present it due to unavoidable circumstances, then that could be considered, fine. Unwarranted, unavoidable circumstances due to extreme emergency, if one could not come, fine, then that document could be considered, means delay could be condoned under this section 25 says so. Section 26 talks about the document executed out of India. Now if some documents have been executed outside India, and the person concerned has brought this document, and means he has arrived in India. Now, from his arrival the 4 months is asked to be computed. Fine. So, section 27 says that if document, sorry 26 says if document executed outside India and from which date it is to be registered, from the arrival of the document in India 4 months is to be counted, 4 months are to be counted. Fine. Section 27 onward deals with the registration of wills. Fine. So, this is again important, but it requires a very exhaustive and lengthy discussion on this topic as to how the will are registered during the lifetime. How can one deposit the will before the registrar? There is a complete procedure. What are the register required to be maintained, and how it is to be opened after his death, who will open it, and how the property which has been mentioned, the immovable or movable property which has been bequeathed by the person, deceased person, to be distributed. These all provisions we will read in detail. Now, इसके अलावा जो अभी important section है, that is from section 47 to 50. These are very important. Effect of registration and non-registration. Fine. Which would be having a supremacy, registered document or the unregistered document. Fine. If it is, document has been executed and not registered, but later on the same property has been registered. Fine. Registered in somebody else's name, then what would prevail, what would be the valid one, and what would attain the supremacy. Fine. These we will read in section 46 to section 50. इसके अलावा जो important है, power of the registrar, how the record is to be maintained, what are the registered one is supposed to maintain. Fine. If he refuses to register the document, then what is the remedy before the aggrieved person? Okay, where could he go? Within how much time frame can he file an appeal? Fine. These kind of provisions are there. So, in a way this act is very interesting, very significant, and although it contains number of provisions, but the important one I have just highlighted. Fine. Section 17, 18 which you are not to leave, then section 20 to 25. Fine. And then section 46, 47 to 50. These are the important provisions we will be discussing during the lecture. Now, let us come to the question. I would try to explain the concept briefly while attempting the questions. So, first question is, lease has been defined in Registration Act, Transfer of Property Act, General Clauses Act, only A and B. Please answer please. Lease Registration Act में तो ये मेंशन है, TPA में भी ये मेंशन है, जनरल क्लॉजेज एक्ट में कहीं मेंशन है लीज, और A एंड B में. योर आंसर प्लीज. A, Priya, you are saying D. The General Clauses Act, lease is defined. Now, we need to see the definition of general clauses. See, immovable property, तो I am pretty sure it is at 3. Registration, transfer of property in General Clauses Act में immovable property का definition तो है. Fine. अब lease का definition General Clauses Act में होना चाहिए, ठीक है. But I am not pretty sure, so we need to see it. We need to verify it first, and then we will attempt this answer. Priya, if you are so sure, you can give the reference. Section number of where in General Clauses Act it has been mentioned, or you can Google it right now. Fine. Anyhow, next question. In the Registration Act, immovable property has been defined under section. So, this is very easy to attempt. उन कौन से सेक्शन में रजिस्ट्रेशन एक्ट में जो है इमूवेबल प्रॉपर्टी डिफाइन है. सी इमूवेबल प्रॉपर्टी का यहाँ बहुत ही एग्जॉस्टिव डेफिनेशन मिलता है. ये केवल ये नहीं बोलता कि लैंड एंड बिल्डिंग, ये बोलता है इवन राइट टू हेरिडिटरी अलाउंसेस, फिशरीज, वेस्ट. फाइन. अगर आपने एक सॉर्ट ऑफ ऑर्चिड भी लिया है, है ना, तो उसकी भी जो इनकम है जो प्रोड्यूस है, दैट वुड बी कंसीडर्ड एज एन इमूवेबल प्रॉपर्टी. इफ यू हैव टेकन द कॉन्ट्रैक्ट ऑफ माइनिंग एंड यू हैव बीन डिगिंग some minerals or mines out of that land, that would also be considered as an immovable property. तो ये concept Registration Act में इतना exhaustive क्यों है, and why this definition has been provided so, ये हम लोग जब lengthy discussion करेंगे immovable property के ऊपर में तीनों का Registration Act का, General Clauses Act का and TPA का, ठीक है, हम लोग जिस देखेंगे कि why so तो यहाँ जो definition है that is very exhaustive, 2(6) में है, ठीक है. एंड TPA में भी डिफाइन है और जनरल क्लॉजेस एक्ट में भी डिफाइन है इमूवेबल प्रॉपर्टी, बट यहाँ 2(6) इज द आंसर. राइट, गुड. The word purport or operate in section 17(1)(b) refers to the ultimate consequences of the instrument, immediate intention of the instrument, collateral effect of the instrument, all the above. Answer it please. See, the very important definition which you have to keep in mind is document of testamentary and non-testamentary documents. Fine. Testamentary, as the name suggests, इसको आप याद रखिए हमेशा, it is my testament, my will. Fine. After my death, the property would be bequeathed to so and so, so and so, so and so in this ratio. Fine. So that is what is testamentary. So the document apart from the testamentary, all others are non-testamentary. Now, non-testamentary documents are those documents, the moment you execute the document, the moment we execute the document, it becomes operative immediately. मैंने आपको प्रॉपर्टी सेल किया, now the immediately or execute किया document, you become the owner, means you are comfort with the title, you become the owner. Fine. So that is what a non-testamentary document is. क्योंकि non-testamentary document 17(1)(b) में यूज़ हुआ है और नॉन टेस्टामेंट्री डॉक्यूमेंट आपको जानना इसलिए ज़रूरी है बिकॉज आपका ये पूरा का पूरा रजिस्ट्रेशन एक्ट है जो उसके अराउंड रिवॉल्व होता है, ठीक है, तो इसलिए आपको इसका डेफिनेशन का पता होना चाहिए, ठीक है। तो अब ये क्या है, द वर्ड पर्पट और ऑपरेट इन सेक्शन, पर्पट और ऑपरेट मीन्स पर्पस एंड ऑपरेशनल, द अल्टीमेट कॉन्सिक्वेंसेज ऑफ द इंस्ट्रूमेंट, इमीडिएट इंटेंशन ऑफ द इंस्ट्रूमेंट, collateral effect of the instrument. So answer is all the above. Priya, you are right. Virender, you are right. Absolutely right. Okay. But the definition is that the document which becomes operative immediately soon after its execution is called the non-testamentary document. 17(1)(d) of the Registration Act applies to a lease for any term exceeding 1 year, a lease from year to year, a lease reserving a yearly rent, all the above. 17(1)(d) में लीज का डेफिनेशन दिया गया है कि वो 17(1)(d) जो है वो कंपल्सरी रजिस्ट्रेबल है। तो क्या वो 17(1)(d) बोलता है कि एनी लीज विच इज एक्सीडिंग 1 year ऑफ टाइम और ईयर टू ईयर एक्सटेंडेबल है और लीज विच इज रिजर्विंग ईयरली रेंट। सो योर आंसर प्लीज, प्रिया ऑल डी, ओके, वरिंदर डी, सीमा अरोड़ा डी, एब्सोल्युटली राइट. So this is the definition provided. See, lease if it is lesser than a year is not required to be registered. Fine. तो यूजली हम लोग देखते हैं जो हम रेंट नोट या रेंट डीड बनाते हैं इन ऑर्डर टू अवॉइड दी रजिस्ट्रेशन फ़ी, हम लोग 11 महीने का करते हैं, ठीक है, ठीक है। क्यों करते हैं? क्योंकि उस पर हमें रजिस्ट्रेशन करवाने की ज़रूरत नहीं है, रजिस्ट्रेशन फ़ी हमें पे नहीं करना पड़ता, ठीक है। बट अगर आप एग्रीकल्चर लैंड की लीज के लिए जा रहे हो तो इट इज़ ऑलवेज इन द बेस्ट इंटरेस्ट ऑफ द पार्टीज कंसर्न दैट इट शुड बी फॉर द लॉन्गर ड्यूरेशन. फाइन. सो अगर वो 4-5 ईयर या 3 ईयर्स का है देन इट इज़ रिक्वायर्ड टू बी रजिस्टर्ड. यहाँ उसमें ईयरली रेंट की प्रोविज़न है, ठीक है, तब भी वो रजिस्ट्रेशन रिक्वायर्ड है. और अगर ईयर टू ईयर है कि 1 साल के बाद में इसको हम रिन्यू करेंगे, ठीक है, ईयर टू ईयर बेसिस पे, तो भी वो उसकी रजिस्ट्रेशन रिक्वायर्ड है एज पर लॉ, ठीक है. 17(1)(d) यही बात करते हैं. नेक्स्ट, सेक्शन 72 ऑफ द रजिस्ट्रेशन एक्ट कार्व्स आउट एन एक्सेप्शन टू, ये किसका एक्सेप्शन है? 17(2), ये एग्रीमेंट टू सेल वाला जो बात है वो करता है. 17(1)(b) का है, 17(1)(a) का है, सेक्शन 17(1)(d) का है. D talks about what? Lease. A talks about gift. 17(1)(b) talks about what? Non-testamentary document pertaining to the immovable property which is valuing more than 100 rupees. ठीक है, तो उसकी बात करता है. तो 17(2) किसकी बात करता है? Agreement to sell pertaining to what? This. 17(1)(b. तो आंसर would be B here. ठीक है, अब इसको समझिएगा. Okay. See, agreement to sell is not required to be registered otherwise, but if you are entering into an agreement to sell, and while entering into an agreement to sell you are handing over the possession also, fine, then if the possession is going to be transferred then it requires a compulsory registration. Why so? Because anybody whosoever has come into the possession, sale deed has not yet been executed. Now, if he in case require dispute emerges between the party, he requires to protect his possession, then therein he can use this document. fine, or clause 17(2) that sir it was a registered agreement to sell, and on the basis of the registration then it could be read into evidence also, it would be taken into and it would be appreciated and appraised by the court of law also. Okay, it is for that purpose only. So, a document which is accompanied by the possession of the property, that is required to be registered as per law now. Fine. Okay. A registration officer may refuse the registration of the document which are in a language not understood, which contain interalineations, blank, erasures or alteration both A and B. We have just discussed it. इसका आंसर बताइएगा आप. अभी हमने डिस्कस किया इंट्रोडक्टरी सेशन में, दोनों ही प्रोविजन डिस्कस किया हमने. Rajesh, you are saying C, okay. Seema, okay. Rajesh, you are saying C. Anybody else want to attempt it? When can, जब मैंने बोला कि रजिस्ट्रार जो रिफ्यूज़ कर सकता है डॉक्यूमेंट को रजिस्टर करने के लिए, ये दोनों ही ग्राउंड के ऊपर में, ठीक है, वो सेक्शन आपका है 19 and 20. If the language is not understood by the registrar and it is not accompanied by the translation, true translation of the document, or if there are blank or the alteration or the inalienation, unless or until it is the sign is there of the attesting party, तब तक वो रजिस्टर नहीं होगा. सो आंसर इज बोथ ए एंड बी इन दिस केस. प्रिया राइट, सी वीरेंद्र सी राइट, गुड. ठीक है, सेक्शन आप जरूर याद रखिए 19 and 20. Section 21 of the Registration Act applies to non-testamentary document relating to immutable property, non-testamentary document relating to movable property, testamentary document relating to movable property, testamentary document relating to 34 immovable property. ये 34 गलत आ गया बीच में. Testamentary document relating to immovable property. Answer it. We have discussed it in the introductory section. Priya, you are saying A, Virendra, you are saying A. Anybody else would like to attempt this? Yes, you are right. A is the answer. As I said that non-testamentary which becomes operative immediately. Fine. So 17(1)(b) deals with it relating to the immovable property. ठीक है. और 21 में मैंने ये बोला था कि if any document is pertaining to the immovable property, the proper description of the document, including the map, boundaries, everything is required to be submitted before the sub registrar or the registrar as the case may be for registration. ठीक है, तो आंसर वुड बी ए हियर 21 का, कि अगर इमूवेबल प्रॉपर्टी से पर्टेनिंग कोई डॉक्यूमेंट है तो उसकी रजिस्ट्रेशन तब होगी जब उसके साथ में सपोर्टिंग डॉक्यूमेंट विच आर रिक्वायर्ड टू आइडेंटिफाई द प्रॉपर्टी क्लियरली दैट हैज बीन प्रोवाइडेड. राइट, नेक्स्ट. Section 23 provides the time for presentation of document for registration before the proper office of 4 months from the date of execution. This is what we discussed in the introductory section. I think everybody would attempt it rightly. Please, I need to know your answer. 4 months, 2 months, 3 months, 6 months. कहाँ से कहाँ तक? Priya A. Anybody else? Virendra A. I want your quick response because we have discussed it. 4 months time is a very important here. 4 months, 4 months, 4 months. Fine. Now the question, if it has not been produced in 4 months due to certain exigencies, emergencies, fine, unwarranted circumstances, uncertainties, then can it be condoned? Yes, it could be condoned. ठीक है, subject to fee or a fine, you could say, which will not be more than 10 times of the actual fee. ठीक है, that could be condoned. Delay in presentation of document for registration can be, next question वही आ गया, can be condoned up to 2 months, 4 months, 6 months, 1 month. Answer. Virendra, yes, okay. It could be condoned, yes. Answer. Delay could be condoned up to कितने महीने की डिले कंडोन हो सकती है? Four months, okay. 4 months यहाँ बहुत इंपॉर्टेंट है. डॉक्यूमेंट्स इट टू बी I mean brought before the sub registrar within 4 months from the date of execution, and delay up to 4 months could be condoned due to these factors what I discussed earlier. ठीक है, तो आंसर would be B. Good, thank you. A document can be presented for registration beyond the period of 4 months of its execution as a matter of right, owing to urgency and necessity, owing to unavoidable circumstances. दोनों ही ये हम डिस्कस कर चुके हैं कि अगर कोई अर्जेंट नेसेसिटी है, अनअवॉइडेबल एक्सीडेंट है, दैट इज व्हाट यू वांट टू प्लीड, but that could be subject to the extra fee, that could be extended, period could be extended and delay could be condoned only if B and C are present. Yes, owing to urgent necessity, owing to unavoidable, so answer would be D. Okay, next. A document executed out of India can be registered if presented within again 4 months, again 4 months. फाइन. तो जब वो इंडिया में आ जाता है डॉक्यूमेंट और उसके 4 महीने के अंदर अंदर उसको प्रोड्यूस कर दिया जाता है, दैट कुड बी रजिस्टर्ड. एग्जीक्यूटेड आउटसाइड इंडिया बट brought in India and presented within 4 months, then that could be registered. The person concerned who has brought the document in India will have to furnish the proof. Sir, I came on March 15th. Now from March 15th I have a time till say April, May, June, July. So I have come in the month of June to you. So I am within 4 months. So this document be registered. Fine. तो यहाँ ये होगा 4 महीने हैं यहाँ पे भी वक्त. But in the you can correct. So B you earlier said, then you said D. So answer is B. Will can be presented for registration within. See, I have not discussed the concept of will, but this question is very easy to attempt कि will को आप कब तक present कर सकते हो registration के लिए. 4 महीने में, 6 months में, any time. Any time, okay. Yes, you are right, it could be at any time. A deed of adoption requires compulsory, optional, no registration. Adoption deed. Anybody else would like to attempt? Priya, Rajesh, Varinder, Priya, you said B, optional registration. See, there is a difference between authority to adopt and adoption deed. If I am authorizing somebody to adopt on behalf of me, fine. So that is what require a compulsory registration. But here the question is adoption deed. Now अगर आपने हिंदू adoption and maintenance act पढ़ा है तो उसमें only one ceremony is mentioned, that is datta homan, which is required to be performed. Even the deed is not required to be executed, only give and take. So adoption deed is neither compulsory nor optional registrable, nor registration is required for this purpose. फाइन. सो आई होप आई एम क्लियर नाउ. तो ये डिफरेंस आपको समझना है कि क्वेश्चन जो है विद रिगार्ड टू अथॉरिटी टू अडॉप्ट है या अडॉप्शन डीड का है. तो यहाँ ये अडॉप्शन डीड है तो इसलिए नो रजिस्ट्रेशन. अथॉरिटी टू अडॉप्ट होता तो ये कंपल्सरी रजिस्ट्रेबल होता. हो दिस इज़ वेरी कॉम्प्लेक्स. मैंने जानबूझ के लास्ट में रखा था क्योंकि हम डिस्कस कर सकें इस पर. एक्स एक्सिक्यूटेड, ध्यान से सुनना है इसको आप, ठीक है. एक्स एक्सिक्यूटेड अ सेल डीड इन फेवर ऑफ वाई ऑन 1/1/2002. एक आपका सेल डीड एग्जीक्यूट हुआ वाई की फेवर में, एग्जीक्यूट हुआ 1/1/2002 को. सब्सिक्वेंटली ऑन 10/1/2002 एक्स एक्सिक्यूटेड अ सेल डीड इन रिस्पेक्ट ऑफ द सेम प्रॉपर्टी इन फेवर ऑफ जेड. तो 10 जनवरी को एक्स ने एग्जीक्यूट किया वन मोर सेल डीड इन फेवर ऑफ जेड. तो 2 सेल डीड एग्जीक्यूट हुआ, एक 1 जनवरी को हुआ, दूसरा 10 जनवरी को हुआ. एक वाई की फेवर में हुआ, दूसरा जेड की फेवर में हुआ, ठीक है. देयर आफ्टर द सेल डीड इन फेवर ऑफ जेड एग्जीक्यूटेड ऑन 10/1/2002 वाज रजिस्टर्ड ऑन 20/1/2002. अब क्या हुआ कि जो 10 जनवरी को हुआ उसको आपने रजिस्टर किया 20 जनवरी को, ठीक है. और जो वेयर एज द सेल डीड इन फेवर ऑफ वाई वाज रजिस्टर्ड ऑन 30 जनवरी, और जो आपका 1 जनवरी को हुआ वो आपका रजिस्टर हुआ 30 जनवरी 2002 को। ये कॉन्सेप्ट है सेक्शन 47 का, ठीक है। अब वो कहता है द सील डीड एग्जीक्यूटेड इन फेवर ऑफ वाई ऑन 1/1/2002 एंड रजिस्टर्ड ऑन 30/1/2002 शैल हैव प्रेसिडेंस एंड कन्फर टाइटल ऑन वाई। तो अब वो जो पहले एग्जीक्यूट हुई है और बाद में रजिस्टर हुई है, क्या वो प्रेसिडेंस कैरी करेगी और कन्फर करेगी टाइटल वाई का? या सेल डीड एग्जीक्यूटेड इन फेवर ऑफ जेड ऑन 10/1/2002 एंड रजिस्टर्ड ऑन 20 जनवरी, मतलब जो 20 जनवरी 2002 को रजिस्टर्ड हुई और 10 जनवरी 2002 को एग्जीक्यूट हुई, वो प्रेसिडेंस कैरी करेगी। या बोथ द डीड शुड बी वाइड और सेल डीड इन फेवर ऑफ वाई एंड जेड शैल रिमेन वैलिड टू द एक्सटेंट ऑफ 50-50। सो सी और डी ऑप्शन नहीं है, हमारा कंफ्यूजन इन दोनों के बीच में है, ए और बी के बीच में। तो दिस इज वेरी इंपॉर्टेंट, सेक्शन 47 का कॉन्सेप्ट है, वेरी इंपॉर्टेंट। आप इसको आप अटेम्प्ट कीजिएगा। सो व्हाट शुड बी द ऑप्शन अकॉर्डिंग टू यू, ए और बी? द डीड एग्जीक्यूटेड पहले हुई, वो प्रेसिडेंस कैरी करेगी इवन इफ वो जो रजिस्ट्रेशन है उसकी बाद में हुई है, और जो दूसरी है वो एग्जीक्यूट बाद में हुई है बट रजिस्ट्रेशन उसकी पहले हुई है। तो व्हाट वुड कैरी दी प्रेसिडेंस? तो यहाँ टाइटल वाई का रहेगा, यहाँ टाइटल जेड का होगा। राजेश, यू आर सेइंग ए, ओके। Priya, you are saying A, okay. But you are saying A, okay. Fine. So we have 3 answers. You 3 are correct. See, you have to see the date of execution. Effect of registration और non registration क्या रहेगा वो सेक्शन 49 में पढ़ेंगे हम लोग, ठीक है। 47 सिर्फ इतनी बात करता है कि डॉक्यूमेंट विच हैज बीन एग्जीक्यूटेड प्रायर इन टाइम दैट वुड कैरी प्रेसिडेंस ओवर द डॉक्यूमेंट विच वाज एग्जीक्यूटेड लेटर बट रजिस्टर्ड प्रायर टू द रजिस्ट्रेशन ऑफ द डॉक्यूमेंट एग्जीक्यूटेड अर्लियर, ठीक है। तो यहाँ पे यही प्रपोजिशन था, सेक्शन 47 का क्वेश्चन है। तो यहाँ प्रेसिडेंस जो है वो वाई का टाइटल कैरी करेगा, और ये जो एग्जीक्यूशन है वो अगर पहले है, रजिस्ट्रेशन अगर बाद में भी हुई है तो डजंट मैटर एट ऑल, ठीक है। नेक्स्ट, this is again a very important question. This is going to be the last question of this discussion today. X, a Muslim, executes a deed of gift on 1/1/2002 of his property to Y, but deliver of possession is not given. अब क्या है कि X एक मुस्लिम है, उसने एक डीड एग्जीक्यूट किया 1 जनवरी 2002 को अपनी प्रॉपर्टी का Y को, बट उसने पोजेशन, डिलीवरी ऑफ पोजेशन जो है वो नहीं हैंड ओवर किया। लेटर ऑन 10/1/2002 एग्जीक्यूटेड अनदर गिफ्ट इन फेवर ऑफ Z। तो 10 जनवरी को एक और उसने गिफ्ट डीड बनाई जेड की फेवर में, विच वॉज अकम्पनीड बाय डिलीवरी ऑफ पोजेशन टू जेड। द गिफ्ट डीड इन फेवर ऑफ वाई एंड जेड वर रजिस्टर्ड ऑन 30 जनवरी 2002 एंड 20 जनवरी 2002 respectively. In this fact, the gift deed executed in favor of Y on 1/1/2002 and registered on 30 January 2002 shall have precedence even if possession was not delivered to Y and gift was not complete. The gift deed executed in favor of Z on 10 January 2002 and registered on 20 so shall have precedence as possession was delivered to Z as the gift was complete under Muslim law. Both the gift deeds shall be void, none of the above. Answer please. Again आपका A और B में से आंसर है इसका। देखो मुस्लिम लॉ में आप ये समझिएगा 2-3 रिक्वायरमेंट है। आपने डिक्लेयर किया गिफ्ट किसी की फेवर में, उसने इम्प्लाइडली और एक्सप्रेसली एक्सेप्ट कर लिया वो गिफ्ट, एंड थर्ड जो है इट मस्ट बी अकम्पेन्ड बाय द डिलीवरी ऑफ पोजेशन एज वेल एज फार एज मुस्लिम लॉ इज कंसर्न। एंड अंडर द मुस्लिम लॉ एज पर सेक्शन 123 और 129 ऑफ TPA, 2 सेक्शन हैं 123 एंड 129, वेयर इट इज़ नॉट रिक्वायर्ड टू बी रजिस्टर्ड। तो ये वाला जो कॉन्सेप्ट है रजिस्ट्रेशन का, ये तो यहाँ छोड़ दीजिए क्योंकि ये मुस्लिम का केस है। अब क्वेश्चन ये आता है कि गिफ्ट अकम्पेन्ड विद द डिलीवरी ऑफ पोजेशन और गिफ्ट मेड डिक्लेयर्ड अदरवाइज, फाइन। तो यहाँ ये जो है अकम्पेन्ड विद द पोजेशन दैट वुड कैरी द प्रेसिडेंस एंड दैट वुड बी अ वैलिड गिफ्ट अंडर द मुस्लिम लॉ। तो ये कॉन्सेप्ट है मुस्लिम लॉ का। तो हियर इन You have to go through the section 123 and 129 of the TPA, Transfer of Property Act also along with it. But ये क्वेश्चन यूजुअली पूछा जाता है pertaining gift, I mean pertaining to the Muslim law. चाहे वो मुस्लिम लॉ में पूछ लिया जाए आपको प्री में, या वो आपको रजिस्ट्रेशन में पूछ लिया जाए, या आपको TPA में पूछ लिया जाए, तो तीनों ही एक्ट में ये बहुत इंपॉर्टेंट कॉन्सेप्ट है. तो गिफ्ट विद रिगार्ड टू द मुस्लिम which you have to go through. Fine. तो यहाँ पे अब क्या है, the gift deed executed in favor of Z registered on so and so shall have precedence as possession was delivered to Z. B would be the answer. You are correct. So thank you very much. It's enough for today. ठीक है. So keep on striving hard. Wish you all the very best and God bless you. तो अभी बहुत सारे बच्चों की जो क्वेरी है कि लाइक सर हमें क्रैश कोर्स में क्या करवाया जाएगा, उसके लिए एक 5-10 मिनट का वीडियो आपके साथ में शेयर हो जाएगा, जिसमें यू विल कम टू नो एज टू हाउ वी आर गोना टीच एंड व्हाट काइंड ऑफ करिकुलम, सिलेबस, कॉन्सेप्ट, I mean discussion, judgments, everything like we would be incorporating it so that हम आप लोग जो है वो equip हो जाएं पूरी नॉलेज के साथ, इन्फॉर्मेशन के साथ में, कॉन्फिडेंट रहें और एग्ज़ाम अपना थ्रू करें. ठीक है. थैंक यू सो मच. थैंक यू.